About order for protections on behalf of children and minors. And there are a lot of issues built into this. So first I want to address, when can a minor get an order for protection for themselves? So if you have a minor who is age 16 or 17 years old, and they come into you and say they've been assaulted and want to seek an order for protection, they can file for their own order for protection in very limited circumstances. If you have a 16 or 17-year-old, and the person they want to file against is someone where they have a child together or somebody where they've been married or are married to, they can file their own order for protections. So just in those limited situations can a 16 or 17-year-old file their own order for protection. All other cases, they cannot file for themselves. Someone will have to file on their behalf. So a 16 or 17-year-old who is pregnant, not sufficient. A 16 or 17-year-old who's living with the person, not sufficient. Someone they're dating, not sufficient. Only if there's a child together or they are or have been married, then they can file their own protective order. Otherwise, someone will have to file it on their behalf. Who can file on behalf of a minor? It can be a parent, a guardian, or any person who is 25 years or older who the court finds is doing it on the best interest of the child. So, and that means any child, minor of any age. So from an infant all the way to a 17-year-old, a parent, guardian, or a person who's 25 years or older can file on behalf of a minor. When you have younger children who are potentially someone seeking an order for protection, the most common way this comes up is a parent who's filing on behalf of the minor child. And the parent can choose a couple of ways to do this. They can file their own order for protection and file also on behalf of the minor children, or a parent can come in and file just on behalf of the minor children. Just remember that if children are listed on behalf of orders, sometimes called OBO orders, if a child is listed as a petitioner, they must meet the two elements to qualify for an order for protection. The child themselves must. The respondent must be a family or household member to the minor child, and the minor child has to have experienced domestic abuse. So, for example, mom has a new boyfriend. The new boyfriend has assaulted the child. It's going to depend, can mom come in and file an order for protection on behalf of the minor child against the new boyfriend? Well, if the new boyfriend is not living in the household, then probably not, because he's not a family or household member, not related by blood to the child, and not living in the household. If the new boyfriend is living in the household, then it's a family household member to the child, and then they would meet the family household element. So it's critical that you think about, is on behalf of orders, what's the relationship between the child and the respondent? Are they a family and household member, and have they committed an act of domestic violence against the child? And if you don't meet those two elements, children can still be included on the petition. So they just can't be listed as an on behalf of petitioner. And much of the relief is the same, whether the children are listed as on behalf of or whether they're just included in the body of the petition. So let me talk a little bit about the relief that you can get, whether it's an on behalf of order or whether the children are just included in the body of the petition. There are specific kinds of relief that can be gotten on behalf of children. So you can get so if a parent comes in, files an order for protection, whether the children are listed as on behalf of or whether they're just included in the petition, the parent can ask for temporary custody through the order for protection, and they can get temporary custody for the length of the order. So that can happen. They can also ask for parenting time. So if they want to establish a parenting time schedule, that can happen through the order for protection. If they want to make sure that there is no parenting time, they can ask for that. If they want supervised parenting time, if they want other kind of limits, like, for instance, I want to make sure that the father of the children has to evidence that they're sober. So they might build in a requirement they have to go to the police station, blow a breathalyzer test that shows that they haven't been drinking before they can pick the children up. So you can build in creative limits to the parenting time. You can also bring in, build in limits to how the exchanges happen. The exchanges must happen in this fashion. Like respondent must stay in the car curbside. Exchanges must happen at the police station. So you can put in all kinds of restrictions and limits and controls around parenting time through the order for protection. The other kinds of specific relief for children in the order for protection is you can ask for child support, and that can be ordered through the order for protection. And sometimes courts are reluctant to set child support, and one of the things that sometimes works better is if you know your court doesn't like to set child support, is ask that it be a temporary setting of child support until you get into court in a family court matter to establish child support that way. So you might not be for the full length of the order, but you could at least get it temporary until something more permanent gets set up through family court. But you do have a right by statute to ask for child support. You can also ask for things like specific exclusions. So under the order for protection, one of the reliefs that's available is to ask to have the respondent excluded from the petitioner's household. You can also ask to have the respondent excluded from the child's daycare. Can be excluded from the child's school. Could be excluded from family members who are routinely taking care of children. So you could ask for those kinds of relief through the order for protection. And it doesn't matter if the order is on behalf of the minor children or they're just included in the body of the petition. The catch-all phrase under the order for protection is that the court can order relief, any other relief that goes to the safety of the victim and the children. So if there are other concerns around the children's safety that you want addressed in the order for protection, you can ask the court, and the court might order that as well. So those are the kinds of relief that you can get specific to children. One of the things when looking at including children in orders or seeking orders on behalf of minor children is to really think through potential risks and benefits of doing that. Oftentimes people think of what are the benefits. I can get child support, I can get specific relief around the children, I can get someone to pay more attention to the abuse that's happening specific to the child, I can stop parenting time. Right? Those are all potential benefits. But there's also potential risks. And depending on your system, depending on the facts of the case, filing an order for protection and including children on it, or filing an order for protection on behalf of minor children may trigger the appointment of a guardian ad litem. Could be good, could be bad. It may trigger a report into Child Protective Services. Some courts automatically refer all order for protections that are on behalf of minor children into Child Protective Services. Other courts will take any order for protection where minor children are included in the petition and refer them over. Other courts don't do either of those things, so you need to know. The other thing that may happen is sometimes the filing of the protective order or making a request for child support will trigger a family court action by the respondent. Now, they have the right to do this no matter what, but sometimes the filing of the protective order is a triggering factor in that. And so it's just talking through risks and benefits with petitioners as they're looking at whether to file for an order for protection when there are minor children. The last thing I want to talk about is, so you have somebody who comes in and wants to file an order for protection because of abuse that's happened to the minor children. How do you prove abuse that has happened against a child? And this can become very difficult because courts generally do not want children coming into the court to testify. It's a pretty standard that the courts don't want children testifying. So then how can you prove that abuse has happened against the child? So if there have been physical injuries, that's easier. You might have medical records. You might have photographs of the injuries. If it's been something that's happened in a school setting, you might be able to have some school documentation of that, or in some other setting. There may be witnesses who have seen that. But too often, a scenario might be the child is at the other parent's house for parenting time. They come home and report that they were physically injured, assaulted, or sexually assaulted while at the other parent's home during parenting time. How do you prove that to the court? So if you have a child who is under the age of 10 years, the parent who heard the report can actually testify to that in court. The fact that the child reported the abuse to them, they can actually come in and be able to talk about what the child said to them. And there's some specific forms that should be filed, et cetera, et cetera. If you're in that situation, really reach out for some assistance. You can reach out to Standpoint, you can reach out to the coalitions, and we can help you file that paperwork. But if you have a child who's, say, 11 or 12, and you have a court that's not going to let this child testify, how do you prove this? It becomes very difficult. So it's one of the things that you want to talk through when you have a parent who's filing an order for protection on behalf of a minor child. How are you going to be able to prove the abuse if it goes into a hearing stage? And so you want to talk this through and think it through and have some approach. Now, some courts will do this thing where they will have guardian ad litems talk to the children. This is a really bad practice, but it does happen. So the guardian ad litem will talk to the child and then come in and then testify in court or tell the judge whether or not they believe abuse has happened. Do not recommend it. It should not be happening that way, but we do know some courts that do that. One of the other things that you can ask for is you can ask for a judge to talk to the child in chambers. This is all stuff that you should clear and talk to the judge's clerk before you get to a hearing to see how they want to handle it. But it's a hard situation when all you have is what a minor child is telling a parent and you don't have any other evidence. So you want to think very carefully about that in terms of going forward. One of the other things to know about guardian ad litems is that guardian ad litems by state law must be appointed if there is reason to believe that there's been child abuse or neglect. And by definition, if an order for protection is filed on behalf of a minor child, that would be saying that the child has experienced domestic or sexual violence. What we also know is that not all counties have enough guardian ad litem resources, and so they don't always get appointed. But if it's an on behalf of order, there's a strong likelihood that a guardian ad litem will be involved. One of the things is to try and seek real clarity in what the role of the guardian ad litem is. The guardian ad litem should be looking out for the children's best interests, dealing with things like what should parenting time look like. They should not be coming in to tell the court whether or not domestic abuse occurred. That's a judge's job to make that determination, not the guardian ad litem. And so getting clarity about whether a guardian ad litem is going to be appointed and being clear about what the role of the guardian is in the case is helpful. And that's work that you should probably be doing, talking to your courts about outside of any specific case, but trying to get clarity from the court and from your guardian ad litem office on those things. So that's just a little bit of background in terms of when you can file an order of protection on behalf of, and some of the specific relief. Think through risks and benefits. Consider how you can find evidence, and just know that guardian ad litems may be appointed depending on your court.